Well, my name is Waldo Jakewith. I'm a fellow with the Jonathan James L. Knight Foundation who funds my project called the State Decoded, which is a GPL software that takes the text of legal codes and uses them to pop up a website with an API and bulk downloads and so on that provides what I hope to be a beautiful and interactive experience to make it easier for people to read laws and legislation and court decisions and so on. But we're not here to talk about me at all. During the computational law panel this morning, we heard about some tools that will automate legal work, and necessarily underlying the sort of, I thought, really impressive work that we saw is a huge amount of design. And when I say design, I mean design of the structure of the data itself, the design of the experience that we want people to have when they use that data, and the design of the interface itself, you know, what people actually look at. And used correctly, that sort of data can tell a story, and everybody can understand a story. So the alternative to that is the status quo. Open any state code, you know, printed version or God help you online, published by West or Lexis, and you will see the appallingly lazy and thoughtless structure and design. It's just basically ASCII text shoveled onto the page without so much of the niceties that are provided by Microsoft Word. So what we're going to talk about here is that design of legal data, and we'll hear from 4 people who are working on doing just that. Just a quick question for everybody. How many of y'all have any experience with user interface or user experience design? Way more than I thought. That's wonderful. Glad to hear it. Okay. So I will say very little about each panelist because, as you'll see, their work really speaks for itself. So we're going to hear first from Margaret Hagan, who's a third-year law student here at Stanford. Her work is at the nexus of art and law. She works across a wide range of media to help people understand legal concepts, although mostly through drawing. A Pittsburgh native, she introduces herself on her website by asking, how can we use human-centered design to make law more accessible, useful, and engaging? Our second speaker is Ed Walters, who's the CEO of Washington, D.C.'s Fastcase, a legal research service that he founded in 1999. Today has over 500,000 subscribers, and he was, in a former life, a speechwriter for President George H.W. Bush. Itai Gurari, we also have, who's the founder of I can never say it correctly. Judicata. I'm so sorry, no matter how many times I practice saying it. Founded in 2011 in Palo Alto, and previously he worked for Google Scholar developing their legal search system. And then our fourth panelist is Daniel Lewis, the CEO of Ravel Law, founded last year by a bunch of Stanford folks with a real emphasis on design as opposed to a purely legal approach. He's previously a fellow at the Stanford Center for Legal Informatics. Because of the inherently visual nature of their work, each panelist is going to give a brief presentation, and then we'll move on to the discussion and Q&A. So please hold your questions until we get to that point. So we'll begin with Margaret.
So I'm going to be very brief here. Like he said, I'm in my 3rd year here at Stanford Law School. And honestly, if I hadn't come to law school, I probably would have made a huge career mistake and tried to become a graphic novelist, because in my spare time, I love to cartoon and draw. And I kind of fell into design during my 1L year as I would take notes from my torts class, contracts class, all these bizarre things that were being told to me, which I found really humorous, but unfortunately were written in very dry, jargony, big case books. So this is what my notebooks looked like, especially after I colored them up after class. I took crazy flowcharts. I started trying to make the law fit into my brain, which is much more visual, much more, I need human faces on things to understand them, and I need to bring the human back into law. This is what I was spending my time when I wasn't studying for my finals. And I started not being ashamed of this and putting it on my blog, and I started getting a lot of hits. And this, I've slowly come to realize that kind of this is my calling, bringing this kind of sense, which is cartoony, a little bit playful, whimsical. Well, this is kind of insane and not readable, but like law needs more of this. Like I've been doing proper user research about how people try to learn law online, non-lawyers, and they want something that's more social, something that's easier to onboard on. They don't want to be reading long FAQs, long Wikipedia articles even are sometimes too dense to get it. They need kind of guidance, flowcharts, pictures, other kind of visual cues, and more natural interactions. And I think that's the real promise of the internet here, is that we can break apart the old models of delivering law and be really imaginative in how we try to communicate what a case says, how to answer a legal question. Like, now is the time before we get stuck in certain mental models or just try to recreate pamphlets or recreate textbooks online. Now is the time to kind of crack that open and be really spirited in how we try to make stuff more colorful, more playful, and just easier to onboard the non-lawyer into. So I'm just taking you through a lot of the art that I've done. You can go to my website, which I can tell you about later, if you want to see more. Yeah, so these are some of my later flowcharts. I think that's all I have to say right now. Lots of questions, I hope. We'll talk about that. Oh, this is a visual I did for Richard Granite's divorce mediation site. I think that service design has a lot to offer, besides just interface design. I think law often is a service, and there are really wonderful professional service designers who can guide people through a journey of law, take them along the steps. So I think that's one of the only other points I want to make, is that thinking about how to take users on a journey throughout law and not just deliver them a single service or a single transaction is a really important framework to start from. So I'll leave it there. Thanks.
Okay, thanks. So I'm Ed Walters. I'm the CEO of Fastcase, and today I'm going to talk about 10 principles of good design. This is every bit as true for web design on the front end as it is for architecture and design on the back end. So when you talk about design in the 21st century, you pretty much have to start with Steve Jobs. It's a requirement. Steve Jobs famously said, "Everyone thinks design is about how things look, but it's really about how things work." If you ask Steve Jobs or Johnny Ive who their design inspirations are, though, they're going to say it's this guy, Dieter Rams. Dieter Rams was the chief design officer for Braun for a good part of the 20th century, and his iconic designs reimagined everyday objects like radios, office objects, in a way that I think made the foundation for industrial design in the 21st century. And Steve Jobs and Johnny Ive have said that Dieter Rams is the inspiration for products like the iMac and the iPhone. So these are Dieter Rams's 10 principles. And I should say they came from a time in the 80s when Dieter Rams was thinking about disposable culture. He was thinking about the things we have and throw away in our lives. And he asked himself, is my design challenging this disposable culture, or is it contributing to disposable culture? And he realized he didn't have an objective way of answering that question. So these are his 10 design principles that help him answer that question. Am I contributing to design that is long-lasting, or am I a part of this disposable culture? He said, good design is innovative. It's not just about taking the same thing and redoing it in exactly the same way, smaller or cheaper. It's about rethinking and reimagining the entire enterprise. Good design makes a product useful. Good design serves the user and not the other way around. If people can't use a product, it's not a solution to their problems. It's just another one of their problems. Good design is aesthetic. We surround ourselves every day with these objects. And whether we realize it or not, they contribute to our mood, to our creativity, to our energy. When we're designing these products that we're going to put in other people's lives, why do it if it's not going to be beautiful? Take the extra moment, be intentional, and design things that are beautiful. Good design makes a product understandable. Good design is its own tutorial. The things tell you their very selves how to use them. When things are designed in a way that is understandable, you'll often hear people describe the objects as intuitive, because their very intuition tells them how to use the product. Good design is unobtrusive. Design gets out of the way. If you're using a product and you're thinking about how it's designed, it's probably too much in the way. So good design is unobtrusive. It gets out of your way. Good design is honest. Honesty here means, in a sales and marketing way, it means that you say honestly what your product does and accept forthrightly its limitations. But it also means, critically, transparency. You know, in my part of the world, in legal research, people have gotten very used to the opposite of transparency. Bills where you have a $500 charge for a hyperlink that you clicked, or a $10,000 bill for a browser window that was left open. Now, I'm not saying these kinds of billing practices are dishonest. They're not lying about what's going on. But there certainly is no transparency in bills that work that way. And we shouldn't accept these things as good design principles. Good design is long-lasting. Products should look as good in 5 years as they do in 15 years and maybe even 100 years from now. Good design is thorough, down to the last detail. There are many places where good enough is good enough, but design is not one of those places. All the way from your home page to the very last menu and how it loads in the browser that nobody uses. Good design is environmentally friendly. When we're talking about software, we don't have to worry so much about people throwing it away in the wrong garbage can. But designed objects should be intentional. They should be made for the long haul and not disposable. Good design is as little design as possible. Dieter Rams had a great quote about this. He said, less but more. Less isn't always more. Less but more almost can't help but being more. Less but more. So we're speaking today at a conference that is partly organized by Robot and Wong. I hope maybe you'll indulge me for a second while I talk just for a second about Bad Lawbot, which is something we at Fastcase rolled out, hopefully with some of these principles in mind just yesterday. Bad Lawbot, if you'll pardon the buzzword, is a big data application that's designed to help authority check, our citator, work better. The idea is relatively simple. Courts cite cases that have been overturned for a million different reasons. Sometimes they're citing it for a different point of law. Sometimes they're citing it to show the evolution of a concept. The Blue Book requires that when a court cites an overturned case in a judicial opinion, they say that it's been overturned. And when they do that, it appears as a signal at the end of a citation. So Bad Lawbot is algorithmic. It actually has read through the 65 million citations in Fastcase's database to extract this information that the database knows that we don't yet know. And then we've basically included all of this information in the authority check report in Fastcase. Whether it's positive or negative, whatever courts say a citation really means, whatever subsequent history is included in those citations we've extracted, we've included it in the authority check report. So negative history is actually flagged in the report. Bad Lawbot works great, and it's getting better all the time. Today, algorithms maybe aren't as good as human editors. So editorial citators like Shepard's or KeyCite today are better than algorithmic citators. But one of the trends we've seen today is that the algorithms get better and better. One day, and maybe a day not very far from now, the algorithms will be almost as good as human editors. And in rapid succession after that, they will be every bit as good, and then they'll be even better. And that sound is the sound of a crumbling empire. I'm going to conclude today with Dieter Rams himself, who is 81 years old this year. And Dieter Rams said, in my experience, users react very positively when things are clear and understandable. That's what particularly bothers me today, the arbitrariness and randomness of the things that surround us, not just in consumer goods, but in advertising and in consumer products. And I would add software as well. These principles of good design are guidelines for all of us. They help us to design things that are more long-lasting, more intentional. And really, because we are all architects, because we are all designers, because we are all contributing to the things in our lives, why not build things that are more beautiful, more elegant, and more long-lasting? Thank you very much.
Good afternoon. I'm Itai Gurari. I'm one of the co-founders of Judicata. I guess I'm here to tell you a little bit about our approach to designing data. So data is at the core of our company. In fact, we talk a lot about mapping the legal genome. What that means for us is taking unstructured legal text and adding structure to it. For example, here we have a couple of paragraphs from a California employment law case. This is text. What we do is, using a mixture of humans and machines, we add layers of structure to that text. And the interesting thing is this structure is data. And once we have the data, we can actually hide the text and start to think about this as data and start to think about how do we design better interfaces and tools for leveraging that data. So we've spent about that's not the one. There we go. Okay. We've spent about 18 months mapping the legal genome, building up software to do that scalably, and building up our first interface to that. And this is a case law search engine. Unlike traditional search engines, which are keyword-based, ours is actually data-based. It's tied to the data that we extract from the cases. So let me, I guess, walk you through a little bit about what we have here. So this is the search page for cases related to employment discrimination in California. At the top here, you've got the statement of the rule, which is you can't discriminate based on age, race, gender, etc. And at the bottom, we have the 201 cases that are actually applying this rule. These are employment discrimination cases. We can create this list because we've gone through and identified in each of these cases, or all the cases, precisely what points of law are at issue. We can then pull out all the cases that relate to a particular point of law. So that's our legal genome, although we didn't stop there with just points of law. We actually went further and said, well, why don't we pull out the procedural contexts? Why don't we pull out the facts? Why don't we pull out the arguments? How much more data can we extract, and how can we make that interface more usable? So this middle part of the page is where we actually have all that other data, which is incredibly powerful. So I guess we can think about for a second race discrimination. If you were to run a search for the words race discrimination on Westlaw in California cases, you get 2,500 results. Those are 2,500 documents that have the words race and discrimination in them, but they're not necessarily race discrimination cases. And in fact, the vast, vast majority are not. With our data, what we can do is simply click on a checkbox, and we're now looking at the 57 race discrimination cases in California. We've just cut down the list of cases by a factor of 50. Within that, we can actually go further. If we're interested in cases where the plaintiff was Asian, click on the Asian checkbox, and we're down to 5 cases. We can look at other facts. For example, what was the employment action here? Was it failure to promote, or perhaps the employee was discharged? Was it an actual discharge or a constructive discharge? We're able to access that just with the click of the mouse with a checkbox. There's no dealing with keywords. Similarly, we can look at the defenses or the arguments of the employer. Perhaps they argue that the employee's performance was unsatisfactory. We just dropped from 57 cases down to 16 cases. And I guess one more I'll show you is the posture. Perhaps we're only interested in cases that come up on a motion for summary judgment. Click on that, and again, we reduce the caseload. So for us, designing data is about thinking about what tools we want to have and what data would make those tools possible. And for us, that means creating data, coming in and designing data that didn't exist before, creating it. And we think that where the future of law is going is a place where everything has been mapped out and we can interact with the data as data and not as a bag of words. Thank you.
I'm Daniel. I'm the co-founder of RavelLaw. And RavelLaw is a legal search, analytics, and collaboration platform for lawyers and law students. And what got me and my co-founder so excited about tackling the legal research space is that there is a big data challenge. There's 10 to 11 million cases in the US system. There's 300,000 to 400,000 new ones being added every year. And that presents a challenge not just to researchers, but to the traditional secondary resources of treatises and practice guides that have a hard time keeping up with tracking all this material and condensing it, and the fact that other secondary resources are now increasingly scattered around the web, whether in firm white papers or the OIE project, a number of different places. And what we've discovered in conversations with hundreds, if not thousands, of lawyers and law students and librarians is that this data challenge creates a couple really powerful insecurities for researchers. One is the question of when is my research done? How do I know when I found everything I needed to find? How can I be sure that I didn't miss a key case or an argument or an insight? And how do I understand what I did find within the broader context of what actually existed and what I may have missed, or understand the whole space? The second thing we hear commonly is that people wonder whether the problem is with them or with the system when they're having trouble doing research. And so, that leads to the fact that they hesitate to ask questions, they hesitate to reach out for help because they're embarrassed they may look stupid. And as a result, they end up duplicating work and potentially doing lower quality work because they didn't get the right guidance. So what we've tried to do with the Ravel platform is to build a system that addresses all of this and starts from the foundation of this is an interesting data challenge. Let's see here. What we've built is based on the fact that we're really interested in the citation network of law. We think it's perhaps the most powerful signal for understanding research and for doing research. It provides a lot of really interesting clues. And the legal citation network is interesting, but it's actually not very dissimilar from a lot of other networks. It's highly skewed, and so what that means is that the majority of influence is concentrated in a relatively small number of cases. For example, 10% of cases aren't cited at all. Another 20% are cited only once. And in the Supreme Court citation network, 2% of cases receive 56% of the citations. So that's sort of the information you're looking for, which really quickly helps you narrow down the relevant sphere of what's important. We've also worked really intensely on building a system that actually works for the way that people want to do research. I think part of our design process is just that. It's not just about how it looks, but it's about the process of how you build that. And for us, that means talking with hundreds of people, putting this in front of hundreds of people, getting feedback, understanding how they're doing research and what they're not able to do within the current approaches. So with that, I'll just jump into a demo. So say you search for something like enemy combatant due process. These are the results you get. So you have a traditional set of text results like you would have in Lexis or West or Google Scholar, but that's also married to a visualization of how all this stuff actually fits together. So you could see that obviously the bulk of this stuff is very recent, within the last 10 years. There is a case from the 1940s that, let's see here, that seems to have some influence, but you could zoom in on the interesting time period here. Having some browser trouble. Let's try this in a different browser here. So you can zoom in and see the sort of hot area of where all this stuff is happening. You can then slice the data in ways that help you understand the story. So as you can see here, there's a few prominent Supreme Court cases of Hamdi and Rumsfeld, of Hamdan, of Boumediene, and you can see that the story of how this case law has evolved has bounced from the Supreme Court down to the circuit courts. You can see this whole trajectory. You can see that these other cases cite back to the Supreme Court, and now if you wanted to find the most recent stuff, you'd look to the circuit courts again. You can also see that as you look at this data in various ways, some things become revealed that you wouldn't otherwise notice, which is interesting about a visualization approach to looking at the citation network. You can see trends, you can see patterns, and you can see outliers. So this case, it doesn't connect to anything else, and it has a red circle around it, which means it hasn't been cited in 10 years. So that's the kind of information that is really hard to convey in a traditional list format, and it's hard to understand when you're looking at 100 different cases in a list, how they all connect. The other part of what we're trying to do is to make the entire process more intuitive and to help you find what you're looking for. So as you read a case, we'll show you the citation graph, and you can get a sense of how it's been cited over time. And we spend a lot of attention looking at how this experience helps you find the exact piece of information you need at the right moment. There's obviously a lot more to the site. It's up, and you can check it out. I'll stop there with that. But I'll sort of end on the note that, we're really excited about the role that technology can play in legal research, but we do not subscribe to the view that legal research can be automated in a way that turns it into black and white issues. We think the most interesting space and the most sophisticated work is happening in the gray areas that aren't very well defined. And that's the kind of system we're trying to build to help really sophisticated users delve into that area and find what they need. And we subscribe to sort of the world of Edward Tufte, where the information design is super critical in making sure that the right information is revealed at the right moment. With all this information, there is an overload, and it's not enough just to surface it. You have to surface it in the right way, and if you don't make sure that the important stuff is highlighted, it's going to get lost in the jumble, and it's going to get lost and ignored, or worse, perhaps confuse somebody else. So that's where I'll stop with that.
I'm going to get things started here with an initial question, but y'all are welcome to step up to the mic as you like to for more questions. So I hope to limit myself to one. I was thinking about how Nolo really did so much to pioneer legal self-help, proving both in a court of law and very much in the court of public opinion that legal data could be designed for a lay audience as a means of self-help. So I'm wondering how much further we can take that. I'm wondering if most of the tools and illustrations that we've seen here make things better for attorneys and make it easier for lawyers to provide services to individuals, or I'm wondering if it's possible that some of what we're looking at here might ultimately be able to replace the services of lawyers for those end users. Anybody?
Well, I just finished a research paper on this question of, well, not exactly.
Great having a student here. This is really helpful.
So I interviewed and then surveyed people, 60 people, non-lawyers, online about how I gave them a legal task and set them free on the internet to try to complete it, basically figure out how to complete a will for themselves. And they really wanted lawyers. They would go down the path of LegalZoom or some of the other kind of do-it-yourself wizard sites, but they didn't trust it, they didn't feel comfortable or supported, and I think there really was a call out for, I do want counsel, I do want this to be done well. But that said, they were really willing to trust things that I would find very untrustworthy, like Yahoo Answers. I got a very big split. Like half of the crowd really love the Yahoo Answers model. They will trust the advice they get on Yahoo Answers. Whereas the other half, of course, when I asked them to go visit Yahoo Answers, they virtually laughed at me and said there is no way I would ever. But I think that reveals something interesting, is that some people do really want the social or kind of like friend-to-friend or peer-to-peer advice, and they almost trust that along with what they would hear from a lawyer, but they kind of want the counsel that Yahoo Answers provides, because there is a lot more kind of, I heard my friend had this happen to them and then they did this, and there's a lot more kind of strategies and like stories on Yahoo Answers, which I think is interesting for the kind of LegalZoom sites or other like wizard sites, which are much more like FAQ based or just ask a question, fill in the form. So thinking more about the kind of stories and peer atmosphere is something that could go towards giving that lawyer feel on a more automated site.
So from your perspective, the barrier here isn't technological, it's what people want. People want a lawyer.
There need to be more of these kind of online ethnographies, though, about whether they really want a lawyer or they just want somebody to tell them stories of what went wrong before and how to avoid that. I think they want strategies, and that's what they're going to lawyers for.
Yeah, so just to maybe add to Margaret's point, since the economic downturn in 2008, the need for legal services is a lot greater, not like 20% greater, like twice as much. And in the same period, funding for legal services is obviously way down. As states have a hard time funding these things, the federal government is feeling pressure, interest rates are low, so IOLTA returns are very low. That's one big way of funding legal services. Into this void, there's a few people stepping in, I think, that are showing a lot of promise for exactly this kind of guidance and self-help for people who need it. I think one of the only ways that you can address these problems today is technology. Not that it's a cure-all. It may just be our best hope at getting the kind of volume that we're seeing today addressed. And one of the most promising things I've seen is the application of A to J Author and Neota Logic, two kind of expert systems that design these sort of interview wizards that help people do self-help. Very powerful tools. In the hands of the right people, they can do a lot of good. So 2 weeks ago at Georgetown Law, there was an Iron Tech Law competition where law students, 3Ls, not software developers, not engineers, just law students, used these kinds of tools to build expert systems, to help people guide their way through certain things. Like, I need to file bankruptcy, what kind should I file? You know, it's not going to completely replace a lawyer. It might do the first 90%. You know, I think the winning entry for last year's competition was same-sex marriage advisor. We're a couple, we want to get married, we want certain rights, we need to figure out what state to get married in. Instead of trying to read the code of 50 states, because we don't have state decoded in all 50 states yet, it's almost impossible, but this is kind of a wizard that would walk people through, you know, what kinds of rights you should be looking for, what's available, and then it would say, you know, you can get married in any of these 6 states. And so these kinds of expert systems are on the way. I'd say that they need a lot of guidance. So smart people in this room, heed my call. Wrap your arms around these tools like Neota Logic, A to J Author, and try to apply some of that expertise in volume. I think there are also good volume business models for law students here. So there's a lot of law students who are just graduated, who are unemployed or underemployed, who could apply their expertise or their smarts or their time into helping to create these systems to help people at volume. They might not be like $500 an hour transactions, but they might be the kind of thing that help you establish a practice or develop your clients at an early stage where you can help build a practice on that at some later stage. I think there's a lot of promise here, but there's a lot of work that's yet to be done.
I would actually add to that, I guess our own personal, or not personal, our own company perspective on that is that the tools that we are building are not really for consumers or for lay people. It's a tool for a litigation context, and I think if you're in a litigation context, you probably should have a lawyer.
Yeah, please introduce yourself and go right ahead.
Hi, I'm Colin Stargar. I wanted to ask a question picking up a little bit on a thread that I think Daniel raised about kind of the indeterminacy that we often see in law, the fact that so much of, at least in litigation, we're talking about argument. And so if you're talking about due process for enemy combatants, one set of lawyers are going to want a set of cases that are going to restrict the rights of enemy combatants. Another set of lawyers that want to enlarge, right? Or if you're talking about employment discrimination, the same thing. In terms of designing and thinking about legal data design, how much do you try to incorporate the notion of sort of the different sides of an argument? And is there a way that these systems can be sort of, the way that they can be used to get sort of a basic knowledge of the field seems immediately obvious from these presentations, but thinking about how it can help advance arguments that are counter to each other. In other words, people looking at the same thing, but they're on opposite sides of the issue.
In our context, we view what we're doing as making that possible, where we look at what are the outcomes of the cases, we identify what are the factors, and we can make it fairly easy to identify where a similar set of factors and arguments went in divergent ways. And if we can bring that to light, then sort of the hope would be we can put the law on rails and make it easy to stay consistent and organize things. But obviously there is going to be some indeterminacy and there's going to be some diversion, but to the extent you can organize things, you can make that much more apparent. But I would totally agree with Dan that that is a problem, that indeterminacy. Yes.
You know, it's questions like that that make me feel like we're living in the past a little bit. I mean, it's kind of a straightforward question. Help me find cases that advance my argument, not that just sort of deal with the same issue. And, you know, the tools we have today to apply to a question like that are so lame. I mean, keyword search, that's kind of the only tool you've got. You know, so we walk around with this one hammer trying to do saw a board with a hammer. Like, it's crazy how bad and antiquated our tools are. Sometimes I feel like we're living in the future, but questions like that make me feel like we are living in the far past. We're living in 1973. The very first systems worked exactly the same way in 1973 as the ones we use today. Lame. I'm super excited to see Itai and Dan up here doing these kinds of things to really innovate and try to bring us into the future. You know, one with kind of semantic meaning and the other with visualization of citation networks. I think both are really, really promising.
Yeah, I mean, just to chime in, I think it's really one of these interesting areas, and we don't hear anybody saying, I want a research engine that'll spit out an answer. Like, nobody wants something that comes out of the black box. I think what they want is a better way to quickly cut to the things that they find relevant and that they need to read and research and think about. And so, you know, in our approach, we're trying to build the tools that let people get down to that granular level so they find what's useful, they understand how it fits in a broader picture, and then they're able to apply and sort of work at a higher level of the crafting and the writing and the argument stage rather than simply the finding stage of finding these are the things I need to build from.
Can I just interrupt for 1 second? I would love to ask a question of the panel up here, just kind of a lightning question in a word or two. Favorite designed website that you actually use? What do you think is the best?
I don't know what's the best, but I like information and I like Wolfram Alpha.
Are we talking law sites?
Whatever in the world.
Oh, I like Kayak.com. I think a lot of information, really clear results, and they give you kind of dashboards to make decisions well.
I like HipMonk as the other travel search company. But I think actually in our design, we don't take inspiration from any particular site. Rather, we try to find the sites that do whatever they're doing particularly well. So, you know, we know that Google spends countless hours thinking about how you do list results and like how you color things and the fonts and all that. And so we try to learn from that. And for visualization, we look at other places. So I think it's about, there's all these different facets of how you do legal research, and we try to pick the right one for the right stage to get some inspirations from.
I actually like John Gruber's Mac blog, Daring Fireball. He hasn't changed the design in years. You look at it and think, you know, somebody didn't even try here, but so much thought went into the exact shade of gray that he uses in the background, the exact shade of white that he uses for the text. So many small, thoughtful touches that I think really make it.
Speaking for myself, Mint.com. I think it's really cool. Not just the kind of design, but the way it works, I think is really good. There's a lot of good competitors for favorite design, but I think Mint's sort of top of my list right now.
Oh, please introduce yourself. And
We also have a request that you could speak closer to the mic.
Okay.
Yeah.
So my name is Jay Mitchell. I direct the Transactional Clinic across the way at the law school. First of all, thank you for the work that you're doing. I think it's just, all of you, I think it's just tremendously exciting with really incredible potential. Just a real-world experience from the clinic. We try pretty hard over there to think of our work product as a product.
Sorry, could you step a little closer to the mic?
Sure, as a product, as something we're making that people are going to use. And we've tried to incorporate basic design thinking, reflect basic typographical principles, use visuals in a substantive way, and go that direction. And two observations. One, from a student learning perspective, approaching it that way makes all of us think harder about the analysis and about how to communicate it effectively. And then certainly from a client point of view, they're thrilled. They've never seen anything like that. They're all medium and large-sized nonprofits. So from a client service perspective, approaching particularly, Margaret, the work that you're doing, it really works, and people take it seriously, and they always say, gosh, I actually understand it, which is really quite a wonderful experience for all of us. So Margaret, you and I should talk. We'd like to engage you as a consultant in the clinic. And again, thank you. This stuff's great.
I should mention that just before this, one of Margaret's classmates was telling me that she had a hard time conveying to her family back in Beirut what it is that she does in studying law as opposed to being the preferred engineer, and that she could never quite make her mother understand until Alumni Magazine arrived with one of Margaret's drawings in it explaining a legal concept. She said, oh, I get it. Now I know what you do. You can explain it all you want, but somehow putting something in this simple, straightforward illustration as she did, it just really cut through. So, please go ahead.
Hi, I'm Jay Mundell from Rocket Lawyer. First of all, fascinating discussion about design. And clearly there are a lot of folks here who have an interest in design. I know at our company we think design first in trying to figure out the complexity of actually getting a customer in front of a lawyer to give them legal services. So that's kind of a credo for us to try to aspire for great design. I'd actually like to ask the panel to kind of share maybe some new frontiers for design, because you guys have been showing some great visualizations of what you've been doing. And I think there are a lot of folks here, aspiring entrepreneurs, who'd love to hear different ways that they can use design to, in a way, kind of disrupt the way we think about law and the way that we show law to customers and to lawyers.
Dan, I'm hoping you can start that off with the idea of telling a story with data.
Yeah, I mean, let me start from a different point, actually. You know, I think when we think about design, it's not so much where do we get inspiration from? It's rather how do we test what we're doing against a lot of people and iterate quickly. So I think our mentality is we're going to build something, we're going to take a crack at it, we're going to make it look as good as we can, but we're going to find a million unexpected things that are wrong with it or that people want to do that we can't do yet. And the sooner we put that in front of people, we're going to learn faster. In the case of how we've been developing our visualization, you know, today it looks nothing like what it did 6 months ago, and it doesn't look like it did a year ago. And so we've been constantly iterating on how it looks and how it feels and what people can do with it. And I think it's been evolving, and we've been honing our understanding of what it should be doing. And it gets to what Waldo mentioned, where it's about how we can use visualization to tell a story. It's a mix of sort of an infographic that's generated automatically, something that's very familiar, that's very intuitive, that's like what you would see in the New York Times, but it's telling you something powerful and it's giving you some insights into, you know, this is the pattern or this is the trend or this is the outlier you should notice. So that's kind of the process that we've been going through, and it's kind of a constant feedback loop. If we try to do something really well and then we put it in front of people because we know it's not going to be perfect.
I think there's a tendency among developers to say, okay, so what are the options? What jQuery plugins exist that look pretty? Great, how can I interface that with my data in a way to represent it in an interesting way? We're limited by our tools. And so I mentioned because, Margaret, you are not at all limited by your tools. You can do anything you want. Are you cognizant of the freedom that provides you?
Yeah, sometimes it's crippling to know where to start, but I think that's what the design process is there for. And if anyone has the ability to take design school classes here at Stanford, especially among the law students, please go do that immediately, because it will give you the insights to set you on that track to see those new frontiers. Because the nice thing about the design process is you can start off and say, I am totally not an expert, but the people who are trying to use the system are the experts. And we need to pay attention to their needs. And it's not just trying to get a will. There are so many other needs underneath that. There are functional needs, I need this legal document, but there are all these experiential needs of their human life that's at risk and that could have opportunities. And I think spending time with the users and trying to unpack everything that goes along with a legal problem is where we can really crack open new markets in consumer law. So if you want to work on that, come with me. I need some comrades who want to kind of spend quality time with users and find these new markets of how do we provide meaningful legal services to people and not just transactional legal services?
You have a question?
Yeah. So one of the refrains of this panel, and a lot of them, but this one in particular, have been this idea that legal information is insufficiently accessible, both in terms of like actually being able to see it at all, and then in terms of being able to understand it. And I'm curious to know what you all do in your design practice to avoid going around the bend, because I mean, in spite of the kind of Dieter Rams principles that we heard at the beginning of the talk, slick design and accessible design can be obfuscatory and can make information obscure, especially when you're trying to make a complex concept accessible. And the best of intentions could wind up making information unavailable in the interest of making other information available. And so I wonder, first of all, how you handle that kind of give and take, and then also whether handling that give and take requires you to build in barriers where you decide that there's stuff people need to know and stuff people don't need to know, and how you handle that.
Yes, from our approach to that is one, transparency is very important to us. We want people to be able to look at our data, to understand it, and get as much information as they can, but we also don't want to overload them with information. If we put too much information out there, early versions of what I showed you were just a wall of text. It was incomprehensible. So for us, that's about showing information and giving little breadcrumbs or ways for people to find more information and explore it, and designing that sort of path of exploration. But crucial to that for us is the idea of transparency and giving people as much information as we possibly can.
Yeah, for us, I think there is potentially a tension between simplicity and complexity, obviously, but I don't think design in and of itself makes one thing worse or better. I think design and powerful tools go hand in hand, and design and access to large amounts of information go hand in hand, where I think our approach is good design can make things better, bad design can make things worse. And so if we focus on making good design, we're going to be able to surface the really important stuff while also showing all the other things that you're not supposed to be looking at.
Just a quick thought about that. I mean, it's always a balance, right? It's funny, there's really no good roadmap for it. I think it's really hard to focus test. So I think it requires people who have a certain aptitude for understanding things visually. Somebody asked Steve Jobs one time if he focus grouped Apple products. And he said, we never focus group our stuff. We just build stuff that we ourselves would like to use. And when trying to strike that balance between simplicity and kind of, transparency and full information, it's exactly this kind of balance. I think Einstein probably said it best. Make things as simple as possible, but no simpler.
So I'm curious about a broader notion of design and law, which is more about redesigning the legal system. And I think that there are some programs that are starting to entertain some of how to do that, rather than redesigning certain preconceived notions of how we're going to implement certain functions today. I remember the beginning of my patent book said if we didn't have a patent system already, we wouldn't create the one we have now. But now that we have it, there's entrenched interests that need to keep it that way. I think sometimes the design process looks at what's already going on, and then it has this empathy focus which says, how can we kind of solve that problem? But that doesn't get you the mouse, and that doesn't get you a lot of things that we kind of see coming out of Apple, which is a completely new way of doing stuff. Case law, for example, could be split front end and back end through an API, so that we have 20 front ends on top of a back end that we know has all of the cases, and there's no issue getting coverage. There's so many things that we could redesign by thinking totally outside of what's going on, and I wonder if you guys could comment on ways that we can break free of what our current notion of legal function is. Thanks.
I've heard of one interesting project in Australia that started in 1999 where they decided to take a human-centered design approach to the Australian tax system. So they had a whole bunch of stakeholders from the federal government, from the tax office. They brought in a lot of design scholars, professionals, consultants, and then kind of workshopped the stakeholders and policy people until they were on board with design thinking, design process. And then it's been 10 years. I wouldn't profess if it's been a success or not, but they've really tried to kind of crack open old ways of thinking and kind of bring in design as a way of seeing things through the user's lens. I think Australia is kind of more open to it than the US, so I wouldn't dare to say how that can happen here.
Maybe it would be worthwhile to say here, we've actually built exactly that. So there is a fast case API that sits on top of the data and the kind of search tier, and we actually power a couple of dozen websites, legal research companies and book publishers and in some cases magazines. But the idea is that you separate out each of these tiers, right? There's kind of an application tier where you have websites and ebooks and really anything in the world, mobile apps. And then you have kind of a search tier. These are the kinds of functions you can do with the data. Show me all of the results that match these questions, or show me the citation network responsive to this query. And then below that you have data. And each one of these is independent. But I think that's a really interesting insight. I mean, historically, they've all been kind of packed together, right? You can't separate one out from the other. And in the future, I think we sort of built this with the idea that we would play nicely with others, that you would have a bunch of different applications that run off of different APIs and different data sets. And I really think that's the way forward. I think there's a lot of promise. It's really cool to see a lot of companies now that are coming up with interesting ways of building the application tier. And I would just hope that we don't all have to, over and over and over again, download the same judicial opinion from the Supreme Court of Connecticut and convert it into XML. I mean, that's a disaster, right? It's a huge waste. We could be applying that brain space to innovation, to helping people solve problems that we haven't even dreamed of today. And what's cool about that is that it kind of works for everybody. It works for people who are doing this today. It works for people who will be doing it in 2016. I hope other people will do that too. I think it would be really interesting to see if there were a lot of different APIs that exposed parts of that network without everyone having to recreate the raw materials. That's a terrible way to do it. And that's exactly the world we live in today, by the way. So Westlaw downloads all the opinions, all the statutes. They update these things every day. Complete commodity. No different from what LexisNexis is doing, what Fastcase is doing. I mean, we're all doing kind of the same thing, and there's no differentiator between that Supreme Court case in Connecticut across those services. So why not have like kind of a central utility that does this? I would love it, by the way, if that utility were called the government. If the Supreme Court of Connecticut had a way to create this feed in a consistent way, or the federal government, or it would be nice to call it PACER also. If there were kind of a central utility that created usable data that we could all use together instead of all downloading it and trying to reformat it and achieve exactly the same outcome. I think APIs are a very good opportunity for innovation going forward.
I'll add to that. We very much view what we're doing in that light. We showed a case search tool, but our focus has been on mapping the legal genome. It's hard to pitch, hey, we're mapping the legal genome, but what is that? Well, it's just information. It's not a product. But what we get out of that is the ability to build a search engine, to build analytics, to maybe get into AI, to maybe get into things that are 5, 10, 15 years away. But at the core of that is data. And what Ed has with his API is he's able to serve data. And so the key thing there is data. And I think you're exactly right. I think that's where it has to go, and hopefully we can get the government to provide that data.
I'm curious about something that a couple of y'all have touched on. Itai, you showed some of this in your presentation, that often to display useful legal information, first it must be teased into existence. That so much of what we have, particularly with case law, is unstructured text, and it's not clearly obvious, at least to the layperson, and I imagine to many people in this room, how you could trawl through that and take useful information and infer things with it, as we also heard about the bad law bot. I'm curious if any of y'all have any stories about a time when you have done that, when you have taken, you've discovered basically a datum hitting somewhere in that noise and pulled it forward and then exposed it in the UI for people to actually use.
Yeah, that's, so we've had a parsing engine. I've been doing that for about 5 years. We've been extracting a lot of information for a long time. And one of the things we started doing about 6 months ago was putting together a new view on cases. How can you show cases in an interesting way and make them more pleasant and easy to read? I didn't show it here, but I could show anyone who wants to afterwards what that looks like. But we realized, in fact, Blake had the insight that, well, we already know what the structure of the sections are in the cases. We have this metadata that we've pulled out. Why don't we just have basically a table of contents that shows that nested structure of the case? Nobody shows that today because nobody has the data. I had no idea when I was pulling that out that we might even do that, but that's one of these things that someone had an insight that we have this data, we can present it, and we got very fortunate.
One thing that we did with data that was kind of surprising when we did it, it seems kind of conventional now, but one of the challenges we were trying to solve when we started Fastcase was the one-size-fits-all nature of keyword search results on Westlaw and LexisNexis. So you would always get your results back, like highest court first, most recent case to oldest case, next highest court, most recent case to oldest case. Maybe the thing you're looking for is the middle of the list. So the idea was we were trying to find ways of resorting that data to bring the best stuff to the top. And first round, we said, well, we'll use the citation network, right? We'll use the number of times that a case has been cited and allow people to resort their search results, citing the most, or sorting the most cited case to the top. Cool. Except, 10 minutes after that, my co-founder, Phil, came to me and said, yeah, so I've been running this for a little while. It's nice. I keep getting the standard for summary judgment at the top, right? It has nothing to do with the search that I'm running. It's just the case that's cited all over the place, and it's just noise. And so we said, well, look, we've run a search. We've got a set of search results. It's a set that discusses this issue in some way. Let's cut out all of the noise outside of this set. Let's just consider this set the universe. And now let's see how many times each of these cases cites every other case in the relevant set of search results. This is geeky, I know. But it was a way of saying, show me cases that are cited for this proposition. And this has been sitting in the citation networks all along. And it turns out if you combine these two tools, just a filter and a sorting mechanism based on how many times they're cited, it's super powerful. And it's kind of the foundation of the sorting stuff we do in search results, but also the interactive timeline, the data visualization of search results that we built in. And when you filter by that, it is magic. It is fairy dust. It's fantastic.
We've discovered a lot of interesting things too from the citation stuff. For example, if you ran a search in Ravel with the word pennoyer, you'd discover two different clusters of cases, one that's about personal jurisdiction and one that's about standing. And you see that they both stem from cases that are titled pennoyer, but they cover obviously very different subject matters. The same thing happens if you run a search for Commerce Clause in the system. You'll discover a whole set of cases about the Commerce Clause, and you'll discover a whole set of cases that's entirely independent that's about the dormant Commerce Clause. So there's a lot of interesting things that get revealed through the citation network that are quite curious, and I think we're just starting to scratch the surface. For example, we've also started looking at the citations patterns of individual judges and their biases and preferences. So these are just early results, and I wouldn't publish them, but it looks like Alito likes to cite himself much more than any other Supreme Court justice.
Well, based on the comments that I've seen on Twitter, I have to assume that Margaret will be signing autographs here in a minute. I hope you'll join me in thanking all these panelists for joining us.